Hello everyone, welcome back to the Law and Obligations and Contracts. Now for this video, we will continue discussing the four defective contracts. So we're done discussing resistable contracts and now we will continue with voidable contracts. If you can recall, yung resistable contract, yung ground natin, yung common ground for resistable contract is economic damage or lesion. Here, in voidable contracts, yung common na ground natin dito is consent, yung about sa consent. Okay? Remember that there are three essential requisites of contracts, di ba? Doon sa essential requisites na discuss natin yon. First one, di ba, is yung consent. Second one is yung object. Third one is yung cause or consideration. Di ba sabi natin na if one or any or all of the essential elements of contracts are not present, ibig sabihin, the contract is not valid. No? Kapag mawala lang yung isa, like consent, or mawala lang yung object, or ang wala is cause or consideration, then sabi natin kapag absence of either of the essential requisite or absent sila lahat, ang effect nun, walang valid na contract. The contract is void. Okay? Now, here in voidable contracts, merong consent, merong object, merong cause or consideration. Kaya lang, merong defect yung consent. Ayan, yung pag-uusapan natin consent. Defect sa consent. Okay, basahin natin yung Article 1390. The following contracts are voidable or annullable when, though there may have been no damage to the contracting parties, those where one of the parties is incapable of giving consent to a contract. Remember, who are those persons incapable of giving consent? Minor for one. Second, insane person. Di ba remember? Third, deaf mute who do not know how to write. So, or demented persons, di ba? Na-discuss natin yan doon sa saan ba? Sa essential requisite ba yun or sa basic principles? Ayan. So, there are persons who are incapable of giving consent. So, once they entered into contract pala, kahit na incapacitated sila to give consent, hindi pala void yung contract. The status of the contract is merely voidable. Kasi present naman yung consent, kaya lang defective siya on account that he's incapable of giving consent. Okay? Second, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Remember, these are the vices of consent. So if there are vices of consent, ang effect pala niya sa contract is voidable yung contract. Though these contracts are binding unless they are annulled by a proper action in court, they are susceptible of ratification. So, balikan natin yung basic na principle ng voidable contract. Di ba sabi ko na isa ito sa mga defective contract na valid siya from the beginning, but you can file an action for annulment if ma-discover mo or malaman mo kung meron siyang ground no, for its annulment. Okay? So valid talaga siya. Pero kung wala kang ginawa, although you can annul it, pero kapag passive ka naman, wala kang ginawa para ma-annul siya, then valid talaga siya habang buhay. Okay? And take note that voidable contracts are susceptible of ratification. Anong ibig sabihin nun? Kunyari, minor ka, nag-enter ka into contract. Diba, under the law, you are incapable of giving consent. Pero, kahit na incapable ka of giving consent, the status of the contract is not void, but merely voidable. Okay? Pero what if, for example, you reach the age of majority, 18 ka na ngayon, wala ka namang ginawa. Hinayaan mo lang, niratify mo. Sabihin mo, okay lang yan. Walang problema. So there is ratification of the contract and therefore you can no longer question the voidable status of the contract kasi nga you have already ratified it. Okay. kanina sa first na defective contract, di ba rescission yun? Now here, ang action kanina is action for rescission. Dito naman sa voidable contracts, action for annulment. Ngayon, discuss natin anong pinagkaiba ng rescission from annulment. So first, the basis of rescission is lesion or economic damage. Yung pinag-usapan natin kanina, di ba, yung value, okay? Sa isang video natin, value, di ba? Annulment, the basis is vitiated consent or incapacity to consent. Okay? Iba-iba yung grounds nila. Second, the defect is external or intrinsic, sabi ng rescission. But in annulment, defect is intrinsic only. Kasi consent, di ba? Third, the action is subsidiary. Di ba sabi natin sa rescission na kapag meron kang ibang remedy, legal remedy under the law, unahin mo muna yon kasi subsidiary lang yung action for rescission. So, secondary lang siya. But in annulment, the action is principal. You can immediately file an action for annulment of the contract. So, kahit pa meron kang ibang other legal remedies under the law, pwede, diretso, mag-file ka na ng action for annulment. Fourth, this is a remedy, okay? While in annulment, this is a sanction. Okay, sanction pala yung annulment. Private interest governs in rescission, but in annulment, public interest governs. Kasi, ano nga yung reason bakit voidable ang status ng mga contracts entered into by minors, by insane persons, by demented persons, by deaf mute who do not know how to write? Kasi, these persons are prone to fraud, or they are easy prey, no, for fraudulent transactions. Kung sa madaling salita, itong mga taong to na minention ko, madali ito silang maloko. Kaya the state wanted to protect them by providing this particular provision of the law, no, para maprotektahan yung mga rights nila. Equity predominates, no, in the rescission. Law predominates in annulment. Plaintiff may be a party or a third person in rescission. Plaintiff must be a party to the contract in annulment. So if you are not a party to the contract, you cannot file an action for annulment. There must be damage to the plaintiff dito sa rescission. But in annulment, damage to the plaintiff is immaterial. So hindi mahalaga kung may damage o wala. In rescission, if plaintiff is indemnified, rescission cannot prosper. Ay oo, kasi na-indemnify ka na, di ba? Indemnity is no bar to the prosecution of the action for annulment, compatible with the perfect validity of the contract. While in annulment, a defect is presupposed. In rescission, to prevent rescission, ratification is not required. In annulment, ratification is required, no, in order to prevent the filing of an action for annulment. Kaya yung sabi ko kanina, kapag nag-ratify ka na in voidable contracts, you can no longer file an action for the annulment of contract. Article 1391. The action for annulment shall be brought within 4 years. This period shall begin. Okay, ito yun. Kanina, di ba, sa rescission, 4 years din yung prescriptive period. Okay? But dito sa, teka muna. Okay. Okay, so, going back, action for annulment shall be brought within 4 years. So, 4 din yung taon within which you can file an action for annulment of contract. At kailan, ang question ngayon, kailan ito mag-uumpisa? So, depende sa ground. Kung yung ground mo is intimidation, violence, or undue influence, so from the time the defect of the consent ceases. So, kung wala nang intimidation, wala na yung violence or undue influence, then from that point in time, uumpisa yung 4-year period. Pero kapag ang ground mo is by mistake or fraud, so from the time of the discovery of the same. So kung kailan mo na-discover yun siya, yung ground, saka pa mag-uumpisa yung 4-year period. And when the action refers to contracts entered into by minors or other incapacitated persons from the time the guardianship ceases. So, ibig sabihin yan, kapag ikaw ay nag-reach na ng age of majority or 18 years old, then dyan mag-uumpisa yung 4-year period. At kapag ikaw naman ay incapacitated person, you are of legal age, kaya lang you are incapable of managing your properties or taking care of yourself, kaya meron kang guardian. So, from the time na nawala yung incapacity mo, that's the time na magka-count yung 4-year period. Okay? So, Articles 1392 and 1396 no, refers to the effects of ratification. Okay? Number 1, it extinguishes the action to annul a voidable contract. Kaya kapag, for example, minor ka, di ba sabi natin, kapag yung minor nag-enter into contract, ang status ng contract is voidable. Meaning to say, valid siya until it is annulled. So what if, for example, you reach the age of majority? So 18 years old ka na ngayon. Pero nag-lapse yung 4-year period. Ay, hindi. Sabihin natin, kahit na nalaman mo na or 18 years old ka na, still, ang ginawa mo is instead na i-question mo yung contract, ipa-annul mo yung contract. Instead, you accepted benefits from the contract. Let's say for example, 17 years old ka, binenta mo yung lupa na nakapangalan sa'yo. Ngayon, pag 18 mo ngayon, instead na bawiin mo yung lupa, ginawa mo, nag-receive ka ngayon ng proceeds ng, ng sale. Yung selling price, tinanggap mo. So meaning to say, there is a ratification. Okay? Dahil meron ng ratification, you can no longer file an action to annul the voidable contract kasi nag-ratify ka na. Paano ka ba mag-ratify? Sabi ng batas, pwede express, pwede implied. Ang express meaning, sinabi mo. Sabi mo na, ay hindi ko na, hindi ko na habulin yan. Valid na yung contract na yan. Okay? Ano yung implied? Yung sabi na example ko, di ba? Gaya ng example ko, instead na i-annul mo yung contract, nag-receive ka ngayon ng benefits under the contract. So, ratified na yung kontrata. So, you can no longer question it. Okay? And take note of the requisites. No? Kapag sinabing requisites, it means that yun yung mga requirement para valid yung ratification. Dapat yung status ng contract voidable. Kasi you cannot annul, di ba, kung hindi naman siya voidable. The person ratifying must know the reason for the contract being voidable. Dapat alam niya na voidable yung contract, status ng contract. The cause must not exist or continue to exist anymore at the time of ratification. The ratification must have been expressly, express or implied. And fifth one, the person ratifying must be the injured party, hindi yung party offender, hindi yung kabilang party, dapat yung injured yung nag-ratify. Okay, basahin na lang yung remaining articles. Ito. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud or caused mistake base their action upon these flaws of the contract. So, in the same example, minor ka, di ba? Tapos nag-enter ka into contract, yung status ng contract is voidable kasi minor ka. On the ground that you are incapacitated to give consent, right? Now, yung person na kakontrata mo, let us say legal age siya. Hindi pwede siya yung mag-allege ng incapacity mo. Kasi that particular incapacity, the minority, the ground of minority can be available only to the minor. So hindi pwedeng yung other party ang magsabi na ipapaanal ko yung kontrata kasi minor yung kakontrata ko. Hindi pwede yon. Kasi nga sabi natin na kapag may isang party sa contract is a minor, ang status ng contract voidable, which means that it is valid until annulled, right? So ngayon, kung hindi magreklamo si minor, edi walang mangyayari, valid yung contract, di ba? Kasi nga, minority is personal to the minor. Siya lang yung makakapag-invoke ng minority niya. Okay, eto, next na sentence. Nor can those who exerted intimidation, violence, or undue influence, or employed fraud or caused mistake. So kung ikaw yung nag-exert ng violence, tapos yung party na inexertan mo ng violence, sabi ng batas, siya lang may right na mag-invoke ng violence para ipaanal yung contract. So ikaw na may sala, hindi ka pwedeng mag-file ng action for annulment on the ground that you exerted violence against him. Okay? Ang ibig sabihin lang nito, ang grounds for annulment are purely personal to the party injured, okay? To the injured party. At yung party na nagkokos ng defect or yung other party na walang defect sa kanya cannot invoke these grounds to annul the contract. So, kunyari no, yung minor, tapos ngayon, gustong ipaanal ng kabilang party. Kasi na-realize niya hindi favorable sa kanya yung contract. Tapos gagamitin niya ngayon yung defense of minority. Hindi pwede yun. Kasi sabi nga natin, personal ito na ground sa minor. Hindi pwede i-invoke yan ng kabilang party, no? Article 1398, an obligation having been annulled, the contracting party shall restore to each other the things which have been the subject matter of the contract, with their fruits and the price with its interest, except in cases provided by law. So example, if a sale of land is annulled, the seller must return the purchase price with legal interest, and the buyer must return the land with its fruits. Okay? However, in the case of Laperal versus Rogers, GR number L-16590, the Supreme Court held that the buyer of a parcel of land does not have to pay rent during the time he is in possession, for the simple reason that the seller was himself enjoying the use of the money delivered so to such seller as the purchase price. No? The court further held that in the absence of a showing that there is a considerable disparity in the benefits derived by both parties, equity will presume that they are more or less the same. Okay? Yan yung parang offset. Offset lang nila yung fruits, no, and interest sa paggamit sa property. In obligations to render service, ayan, what if it is an obligation to do? So the value thereof shall be the basis for damages. Article 1399, when the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. Because, di ba, generally sabi natin, if the obligation is annulled, the contracting parties shall restore to each other things which have been the subject matter of the contract. But an exception to that rule is the minor, or the person incapacitated to give consent. Article 1400, whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return. Okay, he shall return the fruits received, okay, and the value of the thing at the time of the loss with interest from the same date. So kung, for example, yung thing subject ng kanilang kontrata is nawala, okay, through his fault, may kasalanan siya. So ito yung mga kailangan mong i-return. Article 1401, the action for annulment of contract shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has a right to institute the proceedings. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action unless said loss took place through the fraud or fault of the plaintiff. So ano lang ang ibig sabihin nito? Ang ibig sabihin lang nito is, di ba yung minor or yung person against whom na-exert yung intimidation, violence, di ba sabi natin, sila yung mga persons na may right to institute an action for annulment. Pero what if, for example, sila din yung reason kung bakit nawala yung thing, subject of the contract. And merong fraud or merong negligence on their part. So, kapag yan ang nangyari, the action for annulment of contract shall be extinguished. Kasi nga, kasalanan nila kung bakit nawala yung object ng contract. Okay? Pero if the loss was through a fortuitous event, then that's another story. So the rule on fortuitous event will govern. Okay? Article 1402, as long as one of the contracting parties does not restore what, in virtue of the decree of annulment, he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. Kasi di ba yung effect ng annulment is you should return the thing or the object of the contract with interest, no? But if one party will not return it, so yung kabilang party, hindi din siya pwedeng i-compel na i-return yung ano yung na-receive niya under the contract. So, okay, that ends our discussion for voidable contracts. So, see you again for our next video on enforceable contracts. Goodbye!